All rise. The Court of Appeal, Division 1 is now in session.
Thank you. Please be seated. Good afternoon. This is the time set for oral argument in our cause number CV14-0262, Mortensen et al. Versus Gus Rosenfeld et al. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and the client that you represent. Each side will have 20 minutes for argument. And Mr. Piccoli, as appellant's counsel, you're responsible for watching the clock and reserving any time for rebuttal that you might desire. I assume the appellees will divide your 20 minutes however you see fit. We have read the briefs and we've conferenced the case prior to argument. So with those preliminaries out of the way, Mr. Piccoli, you may proceed.
Good afternoon, Your Honors. Russell Piccoli for all of the plaintiffs' appellants in this case. Judges, this appeal effectively turns on a very simple question. Does this 3-page document contain an express non-binding clause or doesn't it? Because if it doesn't contain an express non-binding clause, Judge Gamma's judgment of dismissal in favor of Avondale needs to be reversed. The complaint clearly alleges that the city breached its duties of good faith to cooperate in documenting and completing the Avondale City Center, and under Arizona law, there is no immunity for breach of contract. And if this 3-page document doesn't contain an express non-binding clause, the entire structure for determining liability against the lawyer defending it is different. They will have interfered with an existing contract as opposed to some expectancy. And here, there isn't anything remotely resembling an express non-binding clause in this document.
What about the appellee's argument that the letter of intent is just an extension of the MOU?
Thank you for asking that, Your Honor. On the first level, we have documents that are prepared by seasoned lawyers from prominent law firms. When lawyers want to incorporate other provisions by reference, they do it explicitly. They incorporate by reference. Nothing like that here. Moreover, whether one document is an amendment of another turns on intent. And whatever intent the city may have had for that, they must have forgotten about it for 3 years because they never alleged it in the trial court. It simply pops up in the briefs before you. But more fundamentally, they point in their brief, it's at page 9, to 5 separate provisions that supposedly make all of this non-binding. Let's take a look at them one by one. First one says that there's no commitment by the city to purchase the land. Well, so what? It doesn't say that the rest of the cross promises, of which are numerous in this document, are non-binding, like to recognize winners as the exclusive developer, like to respond to requests for information on a timely basis. It doesn't say anything about that. There are 2 provisions cited by the city that this document in and of itself is not an economic development agreement and that the city retains discretion to enter into one. Winners never contended that this document itself was an economic development agreement. Indeed, if you look at it, it isn't because it doesn't cover anything. And the fact that the city didn't commit right then to an economic development agreement, again, doesn't mean that all of the other cross promises in this agreement and in the later agreement are not binding. It says that the city will reserve the rights for site approval. Fine. It doesn't say that these other agreements are not binding. And it says that certain costs of due diligence regarding these other lands will be at Winners Express. Again, it doesn't say that all of these other cross promises are non-binding. And at bottom, none of these provisions remotely say this paper is not binding. And non-binding clauses are well known to lawyers. They're well known to courts. They say something like, in Johnson, this document is not binding. So hopefully that answers your question, but that doesn't do it. And going to the letter of intent and understanding itself, at least in the trial court, and as far as I can see right now, there's only a single recital that's pointed to that supposedly makes this 3-page document non-binding. And what it says is, it is the intent of the parties to enter into such legal arrangements as are appropriate to finance and facilitate acquisition of real property and planning and construction of improvements thereon. Well, that doesn't say that the document's non-binding. And if you look at the instruments that are being looked at, yeah, they're going to need a lease with National Standard to finance the project. They're going to need contracts with the landowners to buy the property. With respect to developing it, yeah, they're going to need contracts with engineers and construction companies like Tiffany to accomplish that goal. But again, nothing in there says that the document itself is non-binding. And in the absence, according to Johnson, in the absence of an express non-binding clause, you look to the intent of the parties to find out whether an agreement was intended or not. That's bedrock Arizona law. And here, if you look at this document, and frankly, the memorandum of understanding to which you just made reference, Your Honor, there's all kinds of provisions in here that show that these seasoned lawyers from prominent law firms intended an agreement.
But let me just clarify, you have abandoned on an appeal any contract claims predicated on the MOU, correct?
I don't know why they said that. Mr. Mandel didn't discuss it, but I don't know that it's.
No, I think you conceded it in a footnote. So your argument you just made confused me on that point.
I'll concentrate on this document then, Your Honor. Okay. This document has provisions for termination of agreement. Lawyers don't put provisions for termination of agreement in non-binding letters of intent. It's got a force majeure clause in it. It says neither party shall be responsible for failure or delay in performing any obligations hereunder to the extent such failure or delay results from any cause beyond the reasonable control of such party. Basically, it provides an excuse for a claim for damages against the party who doesn't perform because of some act of God. That is not the type of document that seasoned lawyers put in a non-binding letter of intent. It doesn't fit, it doesn't go, it's surplusage, it's meaningless. And when lawyers are going to get together, I mean, presumably one of them, if they weren't intending an agreement, would have said to one another, hey, listen, why don't we have this thing in here? This is non-binding, nobody's obligated to do anything anyway. But that's not what it says. Non-assignment. The interests of winners in the city under this LOI are not subject to the claims of creditors and may not be voluntarily or involuntarily assigned, alienated, or encumbered. Non-binding letter of intent has no interest of anybody. The provision doesn't fit. It evidences that these parties intended to make an agreement, as does all of the cross promises itself in the agreement. Basically, each party under this agreement had obligations to devote their best efforts to accomplish particular things to accomplish this project. Winners was obligated to go out and buy $30 million worth of lands, or at least to enter into contracts to do it. The city was obligated to assist winners in that venture. The parties were obligated to work together to make an economic development agreement. They were obligated to work together to get the lease together with National Standard to work out the financing arrangements. There were various cross promises, and that's what agreements do. And that's what agreements did here. There is no question, absolutely no question in my mind, that there is not an express non-binding clause. Now listen, someday proof could evolve after discovery, and a jury could find that maybe somebody intended that this wasn't an agreement. Maybe lawyers for the city can explain, if it wasn't an agreement, why they're putting in force majeure clauses and non-assignment clauses, but I don't know what that explanation would be unless they intended an agreement. But these papers say, and to the extent that the argument is made that one incorporates another, to the extent that the argument's made, I'll respond. This document says 16 times in it, they calls itself an agreement, 8 times on the last page. Seems to me that's pretty compelling evidence that these people intended an agreement. And if there were agreements, there's absolutely no question. I don't even think there's any dispute. There was breaches. The parties, for one thing, the parties obligated to work together to get a lease together with national standard, and
Well, if there's a breach, we'll get to deal with that if we agree under the 12B6 standard. But there's a claim against the lawyers of aiding and abetting a fraud. And apparently, that claim was dismissed by the trial court, and it's not been moved forward. What's your best argument for why that's still a viable claim in the absence of being able to demonstrate that the city was engaged in fraud?
And can I just jump on that? And
Sure.
Because I think he and I are on the same page. I wanted to talk about that too.
Okay.
In the opening brief and the reply brief, you have not sought reinstatement of counts 1 and 2 from the second amended complaint, which are Winter's fraud claims against the city. But you have sought reinstatement of count 10, which is the aiding and abetting fraud against the lawyer defendants. And so I think both Judge Portley and I are interested in how it's possible to maintain that in the absence of the underlying claim against the primary actor.
as I believe under the economic loss rule, if there was an underlying contract claim, the fraud claim cannot be pursued.
Well, under Carruthers versus Underhill too, because the underlying primary actor was dismissed, this court held that the aiding and abetting claim as to other defendants had to fall.
Then under that, typically under the restatement, you can sue one tortfeasor, you don't have to turn them all. But if that be Arizona law, and I have no reason to dispute that particular point, then no, that fraud claim would not continue to be viable against the lawyers. And from a practical standpoint, if the contracts claim's there, that's what's going to go. The fraud claim was a backup, given what the trial court did in dismissing the first amended complaint, and then in refusing to reinstate the contract claims, and then in providing leave to amend simply consistent with that claim. But at this point in time, I think I'll reserve the rest of my time unless the court has some other questions for me right now. Thank you so much, Your Honor.
Thank you.
Afternoon, Your Honors. May it please the Court. My name is Lauren Stein, appearing on behalf of Appellee City of Avondale. Appellees intend to divide their time evenly, so I'll defer to counsel at around the 10-minute mark. Memorandum of Understanding and letters of intent serve useful purposes in helping to keep track of negotiations that precede complex deals. There's a long-standing presumption against allowing negotiations to turn into binding contracts, particularly if the documents indicate that they are not binding and lack essential terms.
But where in the letter of intent does it have binding language?
And several.
Yes, the letter of intent.
There are several places, Your Honor. It states in section 1.6 that it is 1.7, excuse me, it's the intent of the parties to enter into such legal arrangements as are appropriate. It's contemplated future action. It states that it is subject to documentation in the future in the form of either a lease or a development agreement. And both of those documents are contingent upon future approvals. Indeed, by statute, they require to be approved by City Council. But the letter of intent can't be divorced, Your Honor, from the Memorandum of Understanding. It states in at least 4 different places that it is a continuation of the MOU. But you don't need to take the city's word for it on that argument. You need only look at what Winters Development affirmatively pled in the first amended complaint below. They pled that the document was a supplement to the MOU, that it refined the argument set forth in the MOU. And it's those allegations, Winters' own affirmative allegations, that you must accept as true for purposes on appeal. This notion that the documents are separate and independent was really a fiction that was created in the appellate briefing below. Winters is bound by the allegations that the documents are together. And when you look at them together, or separate, you have expressed non-binding language. You have a statement that this is not a commitment to enter into a development agreement. This is not a commitment to obtain land. The documents require future approval, including City Council approval, and the documents contemplate the execution of future future agreements, whether in the form of a lease or a development agreement.
Well, why not just put language in the letter of intent that says, this is also not binding?
Because it reflects, Your Honor, it is a continuation of the MOU. In fact, it says this is a continuation of the MOU. You can't look at the LOI absent the MOU. In fact, you have to understand the LOI, you must reference the MOU. And magic language isn't required to make the documents be read together. There is sufficient language on the face of the LOI for you to conclude that it is read together as a supplement to the MOU. And again, that's exactly what Winters pled below and is bound by now in front of this court.
Well, then why wouldn't that be a more appropriate for a motion for summary judgment as opposed to, because it seems like that's open to interpretation. And so why wouldn't that be more appropriate for a motion for summary judgment as opposed to a Rule 12b? 6 motion?
For a couple of reasons. First, Winters affirmatively pled it, so they're bound to it, and the trial court appropriately accepted that as true. Second, you can see it on the face of the documents. There's no need to refer to any extrinsic evidence or no need for any future fact-finding. You see it from the face of the documents that they're connected. And second, consistent with the Johnson decision, which is why 12b6 dismissal was appropriate, the documents on their face indicate that they're not binding. And once you find that, the inquiry ends, and 12b6 dismissal is appropriate.
But Johnson had the clear, unambiguous language Judge Orozco was just referring to, saying it shall not be binding on either party, making it unambiguous, and there was no need to look at some of these other factors courts have articulated. It seems to me neither document, but certainly the LOI doesn't have that kind of express non-binding language that Johnson was dealing with.
Johnson didn't say, Your Honor, that there was specific language that a document needs to include.
It didn't, but because it had that clear, unambiguous language, the court found it unnecessary to look at other indicia of intent. And so my question is, I don't think we have that clear, unambiguous language, which opens up some of these other issues that Judge Orozco is referring to that arguably are not 12b6, but Rule 56 issues.
The LOI and the MOU read together do contain sufficient express non-binding language. But regardless, Your Honor, 12b6 dismissal was still appropriate because even the promises that serve as the foundation for Winters Development's claims aren't actually in the documents. So now we're on appeal, and they've bound themselves only to appeal the LOI. The sole foundation under the LOI for their claim against the city is that the city didn't sign a recourse lease with National Standard Finance. You can see that in paragraph 141 of the First Amendment complaint. That obligation doesn't appear anywhere in the letter of intent. In fact, if you look at section 2.1e, the closest that it comes is saying that the city will work closely with Winters Development to try to produce a lease document. That doesn't say anything about recourse or non-recourse. In fact, even under the teacher's line of cases, that is insufficiently definite to enforce any obligation. What's the purchase price? What are the properties that are going to be purchased? What's the price of the property? What are the terms? When is it going to close? What are the terms related to the financing of the property and the construction of the infrastructure? None of that information is there, rendering that entire term insufficiently definite to enforce any binding obligation, and certainly insufficient to enforce the allegation, the foundation of the alleged breach here, which is that the city didn't sign a recourse lease. So even their own allegations don't appear from the face of the document. And so it was appropriate for Judge Gama to dismiss on a Rule 12b6 motion. Now, appellants have argued in their papers to you, as they did down below, that this case really falls under the teacher's line of cases. But even the teacher's line of cases recognizes that it is the exception to the longstanding rule, in fact, the presumption that letters of intent and memorandum of understanding are non-binding. The teacher's case implicitly recognizes that by cautioning courts to be careful to avoid imposing liability and binding obligation where none is intended. In fact, it says there's a strong presumption against binding obligation in agreements that include open terms, call for future approvals, and expressly anticipate future preparation of documents and execution of documents. That's exactly what you have in the LOI and in the MOU. None of the language in there which actually forms the basis of Winters' claims is sufficiently definite None of it's there, indeed, to form the foundation of the claims. Contrast that with what you had in the teacher's case and the Channels Homes case, where you had a plethora of information, in the words of one court. Documents that were replete with the terminology of binding agreements. In fact, those cases said, and those letters of intent actually said, this is a binding commitment to purchase and sell securities. We have a binding obligation. None of that information appears on the face of the LOI or the MOU.
But do they really need to have that binding language? It seems to me that under the line of cases with Johnson, that if it's not to be binding, you have to have there should be explicit language, as opposed to what you're arguing, which is because there's no language in the letter of intent that because there's no binding language, it falls because it's not binding because it falls. That doesn't. And what's your best case to support the fact, or your argument that that it has to have binding language in order for it to be binding?
There's a couple reasons why the claim needs to be sustained, Your Honor, and I think I'll then get to answer your question. Number one, the LOI, whether separate or together with the MOU, contains sufficient non-binding language such that the dismissal was appropriate under Johnson, period. Even if you conclude that there wasn't sufficient non-binding language, the dismissal was appropriate because the alleged foundation of the claim against the city is a purported breach of an obligation that doesn't appear anywhere in the document. So it was appropriate to conclude on its face that there was no claim. And beyond that, to extend, if this court were to extend the teacher's line of cases, the terms are not sufficiently definite by any stretch to impose any binding obligation. And I see that I'm about to expire my time, so I'd like to touch briefly on the interference claims. Now, when it comes to the tortious interference claims, there's a threshold issue that bars both of the claims against the city, and that's the city's absolutely immune from liability under ARS 12-820.01. Absolute immunity exists regardless of the alleged underlying motive. The question is whether the underlying conduct or decision fits within the statutory definition of fundamental governmental policy. And now, while appellants claim that we're advocating a broad expansion of the law, that is not the case, because the question has already been answered by the Arizona Supreme Court in the Cole decision. In that case, the Arizona Supreme Court said interim decisions can be fundamental governmental policy decisions. In that case, the court said city engineers' selection of criteria on which to evaluate intersections, absolutely immune. City's selection of a computer system to process information, absolutely immune. Both decisions related to the broader context of the city's decision on where to locate infrastructure and potential maintenance of facilities. And that's exactly what you have here, because the allegation is that a single email sent to the third-party financing entity is the foundation of the claim. That email was sent in the context of negotiating a multi-million-dollar land and construction deal, and it in and of itself is the city taking an affirmative position on what terms it needs in the deal. And my time has expired, so I'll defer now to the lawyer defendants.
May it please the Court, Susan Freeman appearing on behalf of Gus Rosenfeld, Andrew, and Denise McGuire. Lawyers are not liable to their opponents when they are acting within the scope of their duties as lawyers, even if it is alleged that they made misrepresentations, even if it is alleged that they acted fraudulently, and even if it is alleged that they acted with a selfish motive.
Let me jump in there, because I actually agree with everything you just said, but isn't that a Rule 56 issue? And your briefing makes me think that as well. You talk about how the issue is whether the city attorney's alleged conduct was in the scope of his duties to his client. That does not seem to me like a 12b6 issue. It seems to me like a Rule 56 issue with affidavits from the city saying, yes, he was acting in the scope and he did what we wanted him to do. End of story. It doesn't seem like a 12b6 issue.
Number one, Your Honor, in the Safeway case, the primary case that the court relied upon was Linder. In Linder, our Arizona Supreme Court upheld a 12b6 dismissal of a claim against opposing counsel's lawyers. They did it on the basis of no fraud claim, no intentional infliction of emotional distress against the opposing lawyers, and they upheld a sanctions ruling because they said the claim was directly contrary to longstanding, unwavering, recent, and repeatedly affirmed Arizona law and was entrenched Arizona precedent. That was the basis for a 12b6 dismissal.
But
Second,
here
Your
the
Honor.
second amended complaint, and again, set aside whether it can be proven or can withstand summary judgment, but it does allege fraud. It alleges all kinds of nefarious conduct, again, setting aside whether it can be proven or not. But and your briefing talks, and I mean, I'm quoting from your brief, the issue is whether the city attorney's alleged conduct was within the scope of his duties to his client.
Okay, number one, with respect to fraud, I would point the court to Safeway, where the court said a party to a lawsuit generally may not premise a fraud claim on alleged misrepresentations by adverse counsel. That's a quote from the Arizona Supreme Court in Safeway. Number two, Your Honor, the fact that it was within the scope of the action, within the scope of duties as counsel, is evident from the factual allegations and from the text of the email itself. And that email itself is saying that in the course of negotiations on behalf of my client, the city requires this, a non-recourse lease, in order to comply with state law. On the face of that, he's acting as counsel for the city in the course and scope of negotiations. Second, the city charter requires that all contracts be supervised by the city attorney, and further that purchases of property be by the city attorney. And here, let me just note that, as noted at page 14 of our brief, the issue about appraisals really was something that the city manager did and not the city attorney, as they admitted below. But even if it was by the city attorney, he is saying we need an appraisal, and there are the criteria that we need for an appraisal. Those are actions on behalf of the client city saying this is what we need in order to make these decisions about whether to purchase property. So you have that. You have the city that ratified the decision, ratified it in the notice of termination. And although they've said that the notice of termination should not be considered, they did not contest judicial notice being appropriate, and it does establish the fact of ratification of the city's attorney's actions on the grounds that the city did require a non-recourse lease, and that this was conditioned upon city council approval, and the acquisition was not reasonable and prudent. So whether or not it was reasonable and prudent, whether or not Long v. Napolitano does require this particular non-recourse lease, the city reaffirmed what was done on that basis. Number three, Your Honor, the plaintiffs admitted that McGuire acted at all times in the course as city attorney. They admitted that in the First Amendment complaint. They admitted that in their notices of claim. And the amended.
I had with that argument and the cases you cited is they stand for the proposition that absent a valid amendment of the complaint, those would be judicial admissions that can't be contradicted. Here we have amended complaints, and the second amended complaint says something completely different.
But the second amended complaint still alleged that the city is liable because of what the city attorney did. So it's still saying that it's within the course of his duties because they're saying the city's liable because of what the city attorney did.
That's certainly an inference, but when they say, and it's their allegation that the actions were taken outside the scope of his agency with the city, all I'm suggesting is you're trying to do too much with Rule 12b-6.
Your Honor, I would note that in the oral argument on the motion to amend, they did admit that he was acting within the course and scope of his duties as an attorney. We've cited that in our brief. I would also note, Your Honor, that what he's saying with respect to your acting outside the scope of your duty as an attorney is in summary conclusory allegations and not the factual allegations. The actual factual allegations are the ones that are saying that we are declining this recourse lease. I, on behalf of my client, am sending you this email saying that my client requires this in order to acquire property. And I need this, and I need the appraisal to be as is because they may never develop this property, doing that as an attorney. So those are the factual allegations, and having kind of conclusory summary allegations that say you acted improperly for your self-interest and against the interest of the city is not enough to overcome those. With respect to the contract itself being binding, let me just note that not only as we pointed out, does city council approval have to be made expressly by an ordinance or by a resolution in order to do the things that my client is alleged to have done wrong. I mean, they're saying there's no dispute about a breach. There absolutely is, because the acquisition using a non-recourse criteria and using as-is criteria are not within the scope of the letter of intent. Letter of intent says nothing about those, as noted by the city's attorney. Even if this letter of intent is a commitment to good faith negotiations, it does not equate to accepting whatever terms the opposing party says, especially if you as the attorney think that what the opposing party is saying it wants is contrary to state law, contrary to the best interest of the client. Secondly, I would say that good faith is shown by actually giving a reason, which is this is what is required by state law. And third, I would note that saying that you did not negotiate in good faith is absolutely not the equivalent of a breach of fiduciary duty, or an aiding and abetting breach of fiduciary duty, or an intentional interference with contract.
On the aiding and abetting issue, do you agree that because the appellants are not seeking to revive the common law fraud and the other fraud claim against the city, that the aiding and abetting fraud claim against the lawyer defendants necessarily fails on that basis?
Yes, I agree with that. Also, because there was no notice of claim against the city attorney, and there needed to be a separate one that was raised in the opening brief, which is why we were appropriately raising it in our answering brief, and because the law with respect to no causes of action against an opposing counsel's attorney apply in this context as well.
Can I focus you on one other claim before you run out of time, and that is the intentional interference claim by what have been called the landowners, the people that had the purchase contracts with Winners. There we actually have agreements, and so we've gotten past the first hurdle that arguably some of the others can't hurdle. What's your best argument as to why that should be affirmed, the dismissal of the landowners' intentional interference claim against the lawyer defendants?
Well, one thing would be that the landowners' contracts did not get breached. They expired by their own terms when they weren't exercised by this date.
Now we get back to Rule 56, because that's the argument that you make. You say there was no breach when Winners did not exercise the purchase rights by the agreed-upon deadline as extended. The contracts expired by their terms. How do we know that? We don't even have the contracts. I mean, that's a summary judgment argument.
One of the allegations in the complaint is that the contracts expired. So you have that. But number two.
But let me back up, because one side characterizes these as purchase contracts. You all characterize them as option contracts. I don't know how we can affirm on that basis of no breach when we don't even have the contracts.
Your Honor, you don't need to affirm on the basis of no breach, although I think that is evident from the language in the complaint that says that they expired. The fact is that those depended upon having a final development agreement, and the letter of intent does not get you anywhere close to a final development agreement. As Mr. Piccoli said, it doesn't cover anything. It doesn't say anything about what's to be in that development agreement. So these are contingent in the sense that they will only have a claim for interference if, in fact, the development agreement goes forward and it exists. Second, Your Honor, with respect to the complaints about intentional interference with contract by virtue of sending the complaint or sending the email, the landowners' contracts continued thereafter. So the fact of the email was not something that trashed or extinguished the landowners' contracts, such as they were. The allegation is that the landowners' contracts continued and could be assumed and acquired by the city and exercised by the city. With respect to the appraisals, there's nothing wrong with there's no interference with contract by the lawyers when the letter of intent had completely expired at that point in time. It had ended, and in fact, they were then saying, all right, well, you don't have a SLE, you're not going to go forward with this letter of intent, so what we're going to do is instead, we'll have the city consider acquiring the properties directly. And so that's afterwards.
Wrap up, please. You're out of time, and I'm going to add a little bit of time to Mr. Piccoli's rebuttal.
That's fine, Your Honor. There is strong public policy underlying the basis for not suing opposing counsel's lawyers, and all of that does apply here. Thank you.
Let's give Mr. Piccoli a total of 10 minutes for rebuttal, please.
Thank you, Your Honor. And let's start with that strong public policy that Ms. Freeman ended with. There is a strong public policy that lawyers ought to be protected when they're acting on behalf of their clients. There is no public policy that protects lawyers engaging in wrongful activities against the interest of their clients. And that's exactly what was alleged here. The allegation here is the lawyers were acting for their own economic interests against the interests of the city. They sent Mr. McGuire is alleged to have sent a false email to National Standard to derail the financing, and derailing that financing at that time made it impossible to consummate the contracts with the landowners.
All right, Mr. Piccoli, I feel like in trial you're on the stand, and I want to say this is the argument before Judge Gama on September 27, 2013, and Judge Gama says, in our prior discussions, I think it was asserted by all parties, please correct me if I'm wrong, but McGuire was essentially an agent, that he was working, discharging his responsibilities as an agent for the principal of the city. Now, you're saying he acted independent of his agency relationship? Mr. Piccoli, you. He acted for his self-interest, but he was acting as an agent for the city at the time. That is correct. That is correct. Don't you lose?
No, because an agent can be responsible for his torts. The question is for attorney immunity is different than agency itself. An attorney, presumably even acting for his own lark. The question is for immunity, and you can look at restatement of the law governing lawyers, section 57, comment G, and more interestingly, you can look at the last case that counsel for the lawyers just went, this GIA, I think I'm saying that right, Environmental Inc. Basically, the lawyer on summary judgment has the burden of proof as an affirmative defense to prove he was acting in the interest of his client. It's a different concept. The agent could always be an agent, as a matter of law, is responsible for his torts. Period. That's under the restatement. An attorney can have immunity for his actions on behalf of his client if, among other things, he is acting for the interests of his client. Safeway and these other cases had no question at all about whether the lawyer was or was not acting for the interests of the client. Presumably it was in all these cases.
But if this went back and they file a motion for summary judgment and the city submits affidavit saying absolutely Mr. McGuire was acting within our interests, within our desires, within our directions, you lose.
I don't know. I don't know that that's going to be the proof. I don't know when I take the city council's depositions over here that they're going to say they understood that those appraisals had nothing to do with the properties as being assembled. I don't know that they're going to say that they didn't assume highest and best use, that they were being splintered up into separate pieces of paper over here that had no resemblance. I don't know that the city council is going to say that they understood any of what Mr. McGuire was doing. I don't know that the proof on this email to National Standard is going to be anything like what the city wanted to do. That's why facts need to be developed. That's why matters like this need to come up on summary judgment. And that's why a judge shouldn't just look at a lengthy complaint and say, well, you know what, I think at the end of the day, perhaps, the defendants are going to win, so I'm going to shortcut this right now. And with all due respect, I think that's what happened. But yes, the facts might turn out exactly as you say, Judge, but I don't know. I haven't had a chance to talk with all these people. I haven't had a chance to sit down in front of city staff over here and ask them the hard questions. I haven't had a chance to ask Mr. McGuire any questions. I don't know what all these people are going to say or don't say. And maybe very well, there might be a motion for summary judgment. And if it looks insurmountable, I may just concede parts of it. But parts of it that I know I'm never going to concede are with respect to these agreements and the breach of these agreements. And they're very, very different instruments. The arguments you hear about being incomplete are actually in the wrong part of town as far as I'm concerned. If we look at the agreements in teachers, if we look at the agreements in, I call it chattel lumber because I grew up in Jersey and that's what it was called then, but they were like kind of lists of terms to be agreed upon in an ultimate agreement. It was a preliminary negotiating tool in those cases, but the instruments here are totally different. Frankly, if you look at either of these things, there's no real outline for an economic development agreement. These are things that they're to-do lists of what these people need to accomplish on a pre-development basis in order to move this project to the place where you can even figure out what goes in the economic development agreement. Like buying the land. The land was going to be bought before this whole thing started. The city could have gone out, could have hired some developer to do all this work on a contract basis. Presumably we wouldn't have any question. But the exchange of promises here was a little bit different. The parties agreed between the two of them, hey, listen, we need to get all these things done in order to get this project to fruition. City, you'll do this. Developer, you'll do that. And basically, we will work together to try to get this thing done. And part of it...
But isn't the best case scenario for you that you've got an issue of whether each side used, quote, best efforts? That's all that's being pledged in the LOI. Specified tasks, yes, but best efforts.
Absolutely. That's right. Of course it's right. And best efforts clauses, and we cited a couple cases in the supplemental, best efforts clauses, they're contract clauses. You and I are lawyers. You're not a judge anymore, and we agree to work together to on a particular case. We don't say who's going to do what, but we're going to work together. And if I do all the work and you do nothing, we're not going to split that fee 50-50 or whatever we agree to. We agree to use our best efforts to work together in a cooperative manner. That's the inherent nature of a joint venture. That's the inherent nature. Three of you did the same thing over here. You put your best efforts into trying to figure out what this case is so that you could collectively make the best decision on it. Agreements for best efforts are enforceable. And that's what this agreement was. You do this, I'll do this, and hopefully we'll get this thing together. And one of the pieces of paper, says we're recognizing winners as the exclusive developer. We're going to work together to get the agreements together. We're going to work together to get this thing done. And city, at the end of the day, you're going to get a nice new gleaming Avondale City Center with frontage on I-10 and access to the racetrack over here. And winners, you're going to make a boatload of money over here developing this project and enhance your reputation. That was the bargain. That was the deal. And the fact that these other things had incomplete term sheets over here has nothing to do with what the agreement was over here.
Okay, this exceeds the scope of their argument, but how in the world does Carlos O'Brien's have a claim for intentional interference?
Carlos O'Brien's was promised that this city center was going in. It went on the basis that the city center was going in. Mr. McGuire was involved.
Point to the LOI or the MOU because those didn't exist at the time of the lease. So what is the business expectancy upon which their claims could be predicated?
They had the expectancy of the city center being built. So while it was being built, they'd have all the construction workers coming in over there and eating lunch. And then after the city center was completed, they'd have all the businesses, the outlet mall, the sports festival.
But on that one, that's a pretty far stretch to say that's anything more than a hope.
Well, for purposes of the pleading over here, it's look at Antwerp. Antwerp, the diamond exchange. It got beat up by the Better Business Bureau over here. Arizona Supreme Court says, hey, listen, they had an expectation of further business over here, and Better Business Bureau beat them up unfairly over here. They lost potential customers. Same thing Carlos O'Brien's did. And that's probably pretty much the best I can do on that, Judge. And unless somebody's got some more questions for me, you've been very kind with your time. I don't know how much I am over, but I'm guessing I'm over something.
All right, thank you. Thank you all for your arguments. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.